Hi, good afternoon, everyone. This is Rajiv Khanna from immigration.com, the law offices of Rajiv Khanna PC. Um, as usual, we do this call every other Thursday, and by participating in this call, neither one of us, you or us, are obliged to be attorney clients. We're just disseminating information for everyone. First question I have today. I'll go over the questions first, then I will do follow up questions, and after that, any new questions, if there are indeed any questions that have not been asked and answered before. Okay, so the first question is from Rocking Worder, who's got a conviction for possession of pornography, child pornography, but no jail sentence. So he wants to know whether he can visit the United States or whether he can use the visa waiver program. Two separate sets of questions. You are correct in that if you have been convicted of a crime involving moral turpitude, potentially you are barred from entering USA. But there is an exception to this called petty, Petty, as in small, petty offense exception, which states if your crime was a misdemeanor, punishment less than maximum possible punishment, I think, is a year or less than a year, um, and actual sentence imposed was not in excess of 6 months, whether or not it was suspended, you will be exempt. So once again, crime of moral turpitude means you've got a problem unless you fall under petty offense exception. And if you fall under petty offense exception, then you are forgiven. Okay. So if you do fall under petty offense exception, you know the language, you may want to do a consultation with a lawyer. But if you do fall under petty offense exception, then you can apply for a visa waiver entry like anybody else, as far as I know. Okay. You can double check that with the consulate as well. But in any case, you should be given a visa unless, as a matter of discretion, for reasons other than exclusively the conviction, the consulate chooses to deny. So, plan of action would be as follows. I would suggest you do a consultation, go over the elements of your crime, see exactly what happened. At the same time, send an email, or after the consultation, send an email to the consulate requesting them to give you more information about what your legal standing is, whether they want you to apply for a visa or can you just get a visa waiver. Okay. Now, remember also, so you want to do a Google on petty offense exception. You also want to Google something called 212 in brackets, small d as in doctor, in brackets, Arabic numeral 3. So 212D3 waivers. People who have any kind of um, bar from entering USA can also get 212D3 waivers, which are usually good for a specific entry. So if you're entering, let's say for 6 months, not considering the visa waiver, let's say you get a tourist visa and you are entering for 6 months, with the 212D3 waiver, you are good for that entry. In future, if you want to enter again, you would have to get another waiver again. Okay? So that, I hope, answers your question. It's a little complicated, but that's the way it works. Had Michael wants to know, I want to apply for my naturalization. The question is, does the 90-day rule which allows me to apply for naturalization 90 days before I qualify apply to me? Because I'm not applying in the first 3 years of my green card, I'm applying later on. I've accumulated the 18 months presence. Does the 90-day apply to me even though I'm applying a few years later? And the answer is yes, the same rule applies to you. Okay, so you can apply 90 days earlier. Next question. Oh, by the way, there was a question posted. I think it's in the next page, on the next page. about political asylums. I'm sorry, I don't know anything about political asylums. We do have forums and we do have discussion available for you on our forums for issues related to asylum, but we don't practice that. We've just made it available for you as a matter of public service. So I will not be able to answer your questions about political asylum. Next question is from Dale Santosh, who wants to know, is there any way to know the personal details of my file number? I'm not sure I understand that question. Uh, I guess what you're asking me is you want to know more details about your H-1B, and you can always try doing a Freedom of Information Act request. There's a form for this. I forget what that form is called. I think it's called G639, G as in girl. Uh, you file that form and try to get information from USCIS. It's easy enough to do. It's a one-page form, and it doesn't cost you anything. So file a Freedom of Information Act request. Let's see what kind of information you can get. Lawyerless has been a green card holder for over 5 years, wants to apply for naturalization, but had a tax problem. He did not file his tax return for 2012. He filed it late, just a week ago. Okay. The question on the naturalization application says, have you ever not filed a tax return? And he wants to answer no, because he did file it even though he filed it late. Look, I believe in over disclosure rather than too little disclosure. I think you can handle it one of the two ways, and I would prefer this way. I would say, yes, I have. There's been a time when I did not file it, and then explain that it's not that I did not file it, I filed it late because of certain personal reasons. Okay. And in fact, I'm actually getting a refund. I don't owe any taxes. The second option, this is the option I prefer. The second option is to say no and still explain. By the way, I have said no to question 7A, but I did file one tax return late. In either case, it does not look like it's going to be a problem for you. Can it delay your case a little bit? Sure, but we want to be completely upfront with the USCIS in cases where there's any doubt. Okay, so in my view, say yes, I have not filed once, and then explain it's not that I have not filed, I filed it late. Okay, not a big deal at all, I think. Next question is from P. Sharax 88. Currently working on OPT expiring in June 2015. Employer will of course file on 1st April 2015 for the H-1B. My husband will file my green card in Jan 2015. Can I continue working after my OPT expires? Yes, you can. Because of your April H-1B filing, you become um, eligible for the cap gap benefit. Okay, cap gap benefit. So that's the gap extension that allows you to continue working unless your case is rejected, and you have to stop working if it is rejected unless your OPT is still good. Okay. Uh, if it is selected, you can continue working, and approved, you can continue working till October 1st. After October 1st, you become H1 holder anyway. I'm planning to have a backup I-20 to continue my F1 if H-1B is not selected. Can I continue working on until my OPT expires? Even if I have a different college? I do not believe so. If you have started school with a different school, you have to start attending classes full time. I don't think you can use OPT anymore. Number 3, can I stay in US after OPT expires? Between June and August, if H-1B is not selected, no. You'll have 60 days to depart. Will my green card application be a problem in H-1B approval? No. You can file for a green card. Green card application does not interfere with your H-1B. Next question I have marked as a frequently asked question. We'll handle this a little bit differently. So If the person who posted this question is on the phone, I'll be happy to take their response right now. They have an approved I-140, and I-485 has been pending for over 180 days. Okay. So they were on L1. Now, if they're getting laid off after November 17th, is there anything I need to do to ensure my process is not wasted? See, I'm not clear whether your green card was filed as an EB1C, which is international managers or executives, or whether it was filed as a regular um, form application under EB2 or EB3. In either case, you can take advantage of AC21 portability if you get a same or similar job with any employer. For EB1C employees, it doesn't have to be an employer related to the set of companies they were working for. It can be any employer, as long as the job description is same or similar. But do consult a lawyer, don't take my word for it. Make sure your jobs are compared. Okay. So can I leave the country and come back before November 17th? I believe so, because you have an advanced parole and you are officially working. I prefer that you get yourself an employment offer. I prefer that you file an AC21 letter for change of employer before you travel. That would be the smart thing to do, Milan. Okay, Milan, if you are on the phone right now, press star 3. Press star 3. I want to take follow-ups on this question right now. Anybody has a follow-up on this question? No new questions? This question of AC21. Press star 3. Okay, you are not on the conference call right now. That's okay. We'll go on to the next question. IMI help pre-Q H1B after 6 years. Got H1 transfer to employer A in April 2012 during 5th year. 6 years completed 2013 March. But Dasha is the person whose message it is, was given an extension by mistake for an additional number of years. Got the stamping on it also. So they have a visa until 2015, but went back to India in Feb 2013, which is the smart thing to do, because if you've received a visa extension by error, it's a good idea not to use it. Okay. Now, another employer wants to transfer the H1 and start a fresh green card. Is this possible? Yes, but you would be subject to the H1 quota if you want the entire 6 years of your H1 back. Because you've been outside USA for more than 1 year, you can have the entire, let's see, when did you leave? Feb 2013, yeah. So you've been outside USA for more than a year, you can get your entire 6 years of H1B back if you choose to be subject to, if you're okay with being subject to the H1B quota. Okay. If you want to be exempt from the H1B quota, there is something called remainder option. Remainder option, which works like this. If I have time remaining on my original H1 or extension H1, I can choose to reclaim that and not get all my 6 years back. But then I'm subject to that set of extensions. So if it's based upon a labor cert and the I-140, I can keep getting extensions based upon that. But my quota, I will not be subject to the quota, and I don't have 6 years back. It's a little difficult to explain it, but once you sit down and figure it out, it's really not that difficult to understand. Okay, so you can get 6 years again, but you'll be subject to the quota, unless you want to take the remainder option, if it is applicable. I'm not sure it is. Yeah, in fact, I don't think it is, because you have not applied for a green card. So yeah, you'll have to go through the quota. Next question I have also marked as a frequently asked question. So whenever I mark a question as a fact, I will open the conference to people who have follow-up questions only on this particular issue. So Preeti1911 wants to know about concurrent H1. And you had posted on immigration.com, our main website also. And I had responded, but it was a little difficult to explain everything without having a discussion or at least talking about it orally. So working for company X as a full-time employee on H1B. They filed my green card, I-140 has been approved. Y has worked for me as a part-time W2. But I need to work as and when required. Sometimes I have to work 20, I guess to 30 hours in a week, and sometimes I'll not have to work for months. That's the problem. You see, you can have an H1B for a sliding scale. You can have H1B for, let's say, 5 to 30 hours. Okay. But each week, the employer has to pay you for 5 hours at least, which is the minimum number of hours. You cannot have an H1 for intermittent work. I'll work 30 hours this week, then not work 2 weeks. That's probably illegal. At least I do not know of any way of making that work. So concurrent employment is no problem as long as the employer pays the minimum number of hours that have been mentioned in the concurrent H1. You cannot have intermittent employment. Okay. Does it affect my current H1B with the company X? It does not. Will it affect my green card process? If you are maintaining your job, full-time job, it does not affect your green card process. Number 3 question, is it okay to have intermittent employment? I already answered that. You cannot do that in my view. Getting a new I-94 is not a problem. Will company X know about H1B filed by company Y? Probably not. I cannot think of any reason why they would know. Okay. All right. I forgot to ask. Anybody, Preeti, if you are on the phone or anybody has any follow-up questions on this concurrent H1 issue, please press *3 on your phone. *3. No new questions, just follow-ups on this question. Okay, you're not here either. Let's go on to the next one. Vijay Reddy, my baby girl has a very rare genetic disorder. Treatment is available only in USA. Baby is a US citizen. One of the congressmen is helping to submit a private bill. As of now, I'm on H1B and my wife is on H4. Do I lose H1B status once the bill is submitted? The answer is no. Unless the bill is passed, you will still be on H1B. And even after passing, you'll have to apply for, I think, I could be wrong about this because I'm a little unclear about once the bill passes, do you have to apply for adjustment of status? I think you will have to. I think you'll have to go for AOS and have to file 485. Until AOS is actually approved, you are still on H1B. For people who don't know what private bill is, in extraordinary cases, if a congressman wants to help people where the case is very sympathetic, they can actually sponsor the person for a special law. So a special law is made granting that person and their family a green card. That's called a private bill. Private bill. In fact, Vijay, I will appreciate it if you just do a write-up for the whole community if you are successful and you give us permission to post it, and if possible, even discuss this matter over a conference call with us. It could help a lot of people who are facing extraordinary circumstances. They could also get some help from their congressman if possible. Okay. Next question I have also noted as a fact. This is a fact, starting my own business while on H1. Well, I have mentioned this before. I will say it again. When you are on H1, there are a few things you have to keep in mind. I don't see any problem with passive investment. It is my belief. Okay, excuse me. It is my belief that while you're on H1B and you want to invest money in the stock market for long-term investments, I don't think you can become a day trader. That's fine because it's passive investment. You're not really running the company. Just because you bought 100 stocks in Microsoft, you don't get to run Microsoft. Okay. So as long as it is passive investment on H1B, I think it's okay. But it has to be 100% passive. You cannot even open your mouth to make a phone call for the company or sign a check for the company, in my view. Okay. Can you partner with other people? As long as you don't actively participate in the management in any way and just give them the money and back away, I think that should be okay. Another way you can do an H1 for your company when you have other stockholders in the company, if they hire you on a concurrent H1 on a W-2, so you're working 40 hours for your employer and another 10 to 20 hours for your company, as long as the job is in your field. So if you are an electrical engineer and you invest in a grocery store, that job is not in your field. You cannot do an H1B, concurrent H1B for that. If you are, on the other hand, investing in a company that is going to do something related to electrical engineering, um, and you can actually be employed in either running the company or part-time working for the company, I think that's okay. But then in that case, you will invest as well as do an H1B for yourself and confine yourself to your job description. Okay, I hope that makes it clear. So passive investment is okay. For active investment or where you actively participating, you need to get an H1B. Of course, if you have your employment authorization, that's a completely different ballgame. Okay, now guys, if Ravi is here or anybody has any question on this issue that I just discussed, press *3 on your phone. *3. Okay, so you are also not here. I will go on to the next call. Another very interesting set of questions I have also marked it as a current topic, immigration action by president and immigration law reform. So Anil wants to know, Namaskar Anilji, uh, impact of executive action in November. What will happen to the green card EB2 category? What can he do? And you are right, the president can, within his own power, uh, count the green card differently so that spouses and children are not counted under green card quota. Also, add unused green card of previous years to current quota. He can do both of these things, and he probably will. Okay, and that will immediately increase the available number of employment-based green cards for everyone, EB2, EB3, all these categories. Okay, will we see a tremendous increase in the speed? We don't really know, but over the next few months, I think it would, in my view, it will speed up tremendously. If the president does take that sort of executive action where spouses' children are not counted under the quota and previous years' green cards from all categories in employment are added on to the employment quota. Next question, Anil says, how do you see the future of immigration bills? Um, that is a little difficult to say, okay, because the bill that the Senate passed, I think, is not going to go through. I think the provision about eliminating per country quotas and removing green card backlogs are likely to find a lot of support. And I do think, and I agree with you, that passing small bills instead of one comprehensive immigration reform is likely to happen. There are there are pluses and minuses. When you do small bills, it is difficult to encompass one policy. Okay. But if we were to separate legal immigration from undocumented, we might be able to come up with a very cohesive, very well put together immigration policy. Would they do it that way? I do not know. They have very smart people advising them and on the Hill. But politics and policy and political considerations can make things very complicated. So I don't know how it is going to pull out to come out eventually. There are noises on the Hill. Republicans are saying if Obama tries to pass or tries to pass an executive order, we will sue him. I don't know. I don't think they will succeed in a lawsuit, if the president is careful about exercising his authority and does not overstep. Um, but that's where we stand. In 2016, will the deadlock with Obama on all immigration related bills? I do not know the answer to that question. I think, Anilji, the need is felt by everyone on the Hill and off the Hill. The pain of legal immigration is felt by people, all the professionals, scientists, researchers, doctors, um, you know, professors, all the people who are directly involved, nurses. They feel the pain of problems in legal immigration, but that pain is not well recognized and acted upon. It is kind of anticipated, kind of understood, but not really fully. Businesses are suffering, hospitals are suffering, universities are suffering. But we'll see what happens. Let us hope that this reform does get some attention very soon. I'm looking forward to November. Um, Actually, this question I have also marked as kind of a topic for discussion. Anybody has any comment on this? Press star three. Press star three on your phone if you have any comment on this issue I just discussed. Star three. Comment or question. Okay. Next question also I have marked as a frequently asked question. Can an H-1B visa holder buy a home? The immigration law does not prevent you from buying a home. I know plenty of H-1B people who've got their own homes. Okay. Um, Securing financing is a different issue. So you have to discuss it with your lenders. I believe that even despite the tightening of the credit, lenders are still lending money to H-1B holders. But I am not an expert in real estate, nor am I admitted to practice law in all 50 states that I can comment about the state law, because real estate, etc., could be state law governed. Um, Immigration law is federal, so we can comment about the federal aspects of it, no matter where you are, and represent people from any state in the United States. But when it comes to state law, like real estate, etc., that is a matter governed by other than immigration law, so I can't really tell you. But it is my belief you should be able to. Does it cost a home loan? Does it cost more to get a home loan for H-1B holder? I don't believe so. What will happen if you are fired? Can you manage your house using some property manager or firm? Yes, you can. You can. You can also leave a power of attorney to a friend or relative to sell your property or to manage your property. Can you get a B1, B2 visa for selling or taking care of the property? I have known people to do it. Whether or not it will be approved is entirely based upon the particular incident, but certainly that is a possibility as well. Okay, so anybody has any comments or questions, including Anil, if you are on the phone, please go ahead and press star three. Any comments on this issue? Okay, let's go on to the next question. Um, Tom 16 has a BS 3-year degree in chemistry, MBA 2-year in marketing from India, then an MS 2 years in technology management. So the green card process, if the requirements are BS plus 5 or MS plus 3, I would like to consider myself for the MS plus 3 category. Can I use the experience gained in India after my BS and my MBA, but before the master's degree? The answer is yes. Yes. The difference between qualifying for EB2 through bachelor's plus 5 or MS plus 3 is this. For EB2 BS plus 5, all experience must be post-bachelor's. For MS plus 3, the experience can be pre-master's or even pre-bachelor's. No problem there. Next question is Muhammad, who is on adjustment of status. Once again, I remind people, a lot of people logged in later. I remind people I will not be able to answer questions on political asylum. So please, I apologize for that. I have no information on political asylums. We don't do that kind of law. Our work is primarily in the legal immigration field. Okay. We have the option available for you to discuss your issues, but we don't participate in those discussions, nor do we know anything about political asylum. Okay, so I am on adjustment of status. Priority date July 2006 in EB3. I still have my H1B and working on H1B with company A in Virginia. So now I've got a teleworker position. I think we've discussed this on immigration.com also. I think you posted this, but I'm not sure. So, will my job conversion to teleworker have any effect on my green card? Well, it can. It can. Okay. You should discuss with your lawyers the advisability of filing an AC-21. Uh, but because you're AC-21 eligible, I'm assuming that your I-140 is approved and 485 has been pending more than 180 days. The relocation through telecommuting should be very easily accommodated under AC-21. Okay. For H-1B, if you move more than 100 plus miles or so, an H-1B amendment should be filed if you want to stay on H-1B. But if you want to move on to roll on to EAD, then of course you don't have to do anything except the company has to prepare a new I-9 for you. Company will not bear any additional immigration expenses. You can hire a lawyer for yourself for AC-21. I strongly advise that you file an AC-21. Okay. H-1B, if you want to go to EAD, no problem. Forget about H-1B. But for green card, I think an AC-21 would be a good idea. Next question is from Joseph. Somebody in his family who was a green card holder committed fraud. But the bigger problem is they did a Social Security Administration fraud, and then they filed for naturalization without disclosing crime. See, the first part, of course, is problematic and can be a problem for naturalization and probably will be a problem. And in fact, if it is a felony, the person is actually deportable. Their green card could be canceled unless they qualify for certain reliefs. But by making a misrepresentation or naturalization application, they have created a much bigger problem. Not only can their green card their naturalization would be denied, their green card can be taken away, and they could be permanently barred from entering US. Okay. So please provide guidance or clarify which federal regulations apply. Um, I believe 8 CFR 212A, which is a criminal because of the Social Security Administration crimes, conviction for crimes. And also, there's another under 212, under 8 US, 8 CFR, 8 Code of Federal Regulations, 8 CFR 212. Just look at 8 CFR 212. Criminal grounds and immigration misrepresentation ground. Both of these grounds apply, and this is a big problem. Okay. Next question is Ian. Ian has an additional question for us that he had posted earlier. I'm on a valid and stamped H-1B work permit visa. Got to go to India in December. Wife is planning to sponsor my green card through marriage. Yeah, you can file your green card now. It does not interfere with your H-1B filing. You're going to come back and you're going to work for the same company. Your H-1B continues. File for your green card. I don't see any problem at all. Okay, so go ahead. Next question is from Makar. Makar, I appreciate your kind words about our ability to help everyone. We appreciate it. We enjoy it too. You were planning on a one-on-one consultation, but I had mentioned that you should try to use this first. Of course, why spend money if I can give you my time free anyway? So just to give you a brief summary, priority date April 2008, 485 was filed in Jan 2012. Dates are retrogressed. Oh, okay. So you want to know, should I file a writ of mandamus? Please be very careful. I actually had pulled up, if you go to our free conference calls for US immigration questions, and you look at the video recording from September 18th, I have discussed this issue, this writ of mandamus issue in great detail. Okay, listen to that call. My general advice is to avoid it. Going through congressmen, going through ombudsmen is the right thing to do. Um, if you have to, then somebody should study the law in your particular region, how federal courts in your region think. It's not impossible to win these cases, but sometimes even winning is not much help. So listen to that discussion we had, okay? I'm not going to repeat that here. And if you still have questions, get back with me, okay? Crazy Ben wants to know, currently I'm on H-1B, company is planning to file my green card. I've completed my master's from USA and did unpaid OPT. Well, if you go to our immigration.com and look at the notes from our own cases, we won a series of cases where the government had taken the position, well, you can't work without getting paid on OPT. And we said that is absolutely incorrect application of law, and they reversed themselves. So, in my view, read those cases. I think they apply to your situation. There is no law that says your employment on OPT has to be paid employment, whether it is the first 12 months or the second 17 months. I believe, it is my opinion, I'm not sure government will agree with me, at least they agreed in those cases that we filed, that you should not have a problem. Okay. Can I mention my CPT work experience? Why not? Absolutely. Absolutely. I don't see any problem with that. But really, these are issues that your lawyers should be deciding. I can point you in the direction, but the decision should be made by our lawyers. Next question um, from Kumar Sena, who wants to know reusage of H-1B stamping. Kumar, the law is still the same. If your H-1 visa stamping was with employer A, and then while you're in USA, you applied for a change of employers and you went transferred over to employer B, you can still use the same visa stamp as long as you've never been out of status. You should not have any problem. Okay. All right, let's look at, I think there are two more messages. Let's see. From Jai Ho, um, my wife and I got my immigrant visa, I-551 stamped on passport. Um, okay. Okay, so the question is about the baby getting the green card. The law is, I think, I could be wrong about this, but I think if the child is under 2 and the mother or father, parents are green card holders, as long as the child lands in USA before the age of 2, they should get their green card entry as well as green card. You may have to apply for it separately. I don't remember the details, but definitely there's a provision for child under 2 to be given an entry. And whether they are given a green card at the port of entry or you have to apply for them, I don't recall. This information is available on USCIS website as well as State Department website. Okay, so yeah, there's definitely a provision there, so you can rest easy. And the last question from Leslie, I'm sorry, Leslie, I don't know anything about political asylums. All right, folks, let's start with follow-up questions. Anybody who has a follow-up, not a new question, a follow-up on posted questions, press *3, *3. Press *3 on your phone. Huh, that's unusual. Okay, anybody has any question at all, new, old, doesn't matter, press *3. I wonder if *3 is working. Press *3, guys. Huh. Anybody has any question, new or old, press *3 on your phone. Maybe *3 is not working. Let me unlock the conference. What I want you to do is, oh, it is working. I just have a hand up. There's a lot of people on the phone, but I guess only one person has a question. Okay, Atlanta, Georgia, I'll get you in 1 second. Once again, any question, new or old, press *3. Press *3. *3 is working. Press start. Okay, we have only one more question. Very good. Let's get on it. Um, Atlanta, Georgia, go ahead, please.
Hello?
Yes, sir.
Yes, sir. Sir, actually, my date is current right now, and on computer it shows that request of evidence has been sent on this August 4th. But I haven't received till now any request of evidence. Neither my attorney has received it. And when I call them, they are saying that we will send it back. But my wife's request of evidence has been received from my attorney, and the last date for it is 28th of October. Until now, I didn't got my request of evidence, and date is current. And it says that if I don't set request of evidence on time, they will deny my case. I keep calling them; they are not sending me request of evidence. They send me a letter stating that you should check your address and attorney check with your attorney. I call them again 2 3 times. My address is correct. I'm calling my attorney. I'm not getting any request of evidence. So does the case get denied if I don't send request of evidence? It
All
is a
right.
medical because my wife got medical.
All right. This one is an easy one to answer. Okay. First of all, don't worry.
Sorry, sir.
I said, first of all, don't worry. Even if the case does get
O-
denied, I don't think it's a major problem. It can be reopened. Of course, in the first place, I don't think it will get denied. As long as you have opened a formal request with the service to be sent an RFE and they have that in their record, you will not get a denial that easily. Okay, so you should be all right.
Okay, so
What you sh-
okay.
what
So I keep calling them and she gets the RFE.
Yes, what you do is you tell them that I want an action request opened up, a request for action request opened up, and I still have not received my RFE. Will you please make sure that I get my RFE? You should also note down the time and the date of the call and what was said. Okay.
Okay.
You haven't done it in the
I'm
past.
doing that.
Yeah,
Yes.
you haven't done it in the past. That's okay. Do it now. I also recommend that you open an ombudsman's request. Ombudsman's request. You know what that is?
No, I don't know, sir. I'll write it
Okay.
down.
Write it. Write it
What
down.
request you said?
Write it down. Just Google or Bing or Yahoo, whatever it is, just search engine, type USCIS space OM,
Okay.
O, M as in Mary, B as in boy, U, D as in doctor,
Okay.
D as in doctor, S as in
Yeah.
Sam. Ombuds, man as in man, woman. Ombudsman. OMBUDSMAN. Did you get it?
OMBU.
D as in doctor, buds, ombudsman.
Okay. Ombudsman. Okay.
Now, ombudsman is a special office that helps people. It's an office within USCIS, but it is their responsibility to help people with USCIS problems. When you type USCIS space ombudsman, their website is the first one to pull out. You can open a case online and they'll follow it up for you.
Okay. Okay.
Do all these things, you'll be fine. Don't lose sleep over it. You'll be okay.
Okay. Okay. Sir, please can you say once again the spelling because it's not that clear.
Okay, I will say it. O, M as in Mary, B as in boy, U, D as in doctor, S as in Sam, M as in Mary, A as in apple, N as in Nancy. Om buds man.
Ombudsman. Okay. Okay.
What in
Okay, sir.
what
I'll
in
keep calling
what?
them.
Remember, there was a big fight in India about Anna Hazare about the Lokpal bill. Are you?
Yeah.
Yeah, Lokpal. Lokpal in English is called ombudsman. Okay.
Okay.
Good luck.
Okay. 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 Thank you so much, sir, for your
You're
help.
welcome, sir. Bye bye. Okay, I have one more question. It doesn't look like there are any more questions from Delaware. Delaware, go ahead, please.
Hi, Rajiv. Actually, I have the question regarding the 19 for
19.
OPT.
One second. Oh, the unpaid OPT.
Correct, correct. So, like for 12 months, I have heard that, that's fine. But is it okay for another 17-month OPT to get unpaid
Um,
in like first
that
3 months?
that issue did come up. I do remember looking into it, and I do remember winning a case like that. Okay.
Uh,
I believe
and
I'm right. Unfortunately, I don't have my colleague who worked on that case with me here, but I'm pretty sure you're going to be fine.
okay, so that would be fine, I guess.
Yes, sir.
Oh, okay. And if
Act,
I don't
act,
mention that, then I don't need to worry at all, right?
no, no, no. I think whatever the truth is, you should mention it. I mean,
Okay.
discuss it with your lawyers. In my belief, it is my belief you should mention everything truthfully. If the forms ask for the information, give it. Of course, if they don't ask for it, you don't have to give it.
Okay, okay.
All
Okay.
right.
No
Uh,
problem. Thanks for your help here.
you're welcome. Good luck. Okay, guys. It looks like we're done for the questions today. I'll make one last invitation. Anybody, any question? Press star three. Okay, there's one more question, I guess. This is from California. Okay. All right. So I guess that's the last question we have for today. Well, very good. I do appreciate all of you being here, though. I must tell you that. Okay, California, go ahead, please.
Rajiv, my question is about two things. The first is my employer has filed my green card petition and the labor has been approved. So the perm has been approved, and they're going to file the I-140 with all the required documents, etc. Now, I was born in India. My fiancée was born in Nepal, but we are not yet married. So uh, I'm wondering if at this point of time, I know that the I-485 can be filed with the I-140 if the priority date is current, and the priority date would be current for Nepal, people born in Nepal. And would the fact that my fiancée was born in India, in Nepal, allow me to file the I-140 and 485 at the same time after the marriage?
Yes, if once you get married, not as a fiance, but as a spouse, you can use her country of birth as your country of chargeability. That's called cross chargeability. I'm sure you know that. In under cross
Mm-hmm.
chargeability, if the date is current because of your wife's country of birth, you can file everything concurrently. Make sure the papers are clearly marked cross chargeability, spouse born in Nepal.
So, if the marriage is, let's say, 3 months down the line, um, should I get the I-140 filed at this point of time itself and make those related changes after the marriage happens?
So your question is, should I do I-140 first and 485 later? Is that your question?
Well, I don't know what's the best course of action because it'll probably take another 2 to 3 months to get the marriage done and her documents prepared. At least 3 months, and I only have 6 months of H1B remaining, so I need to kind of figure out how soon I can get the I-140 approved and my H1B extended. Uh, while I know that if we were married, we could have filed the I-140 and I-485 at the same time. So, what would be your advice in that scenario?
Well, there's a professional angle here and there's a personal angle. Okay, I can comment about the
Right.
profession. I can comment about the professional part. The personal side, you have to decide. If I were in this situation,
Mm-hmm.
if I were in this situation, I would get married, and you can do a court marriage, get married, and file for I-140, 485 together. You can always do religious ceremonies, religious marriages later. There is no law that
Oh,
stops you getting married to the same person 50 times if you
Okay.
want. Okay,
Okay.
that's one option.
So I'm trying to understand the reason you're advising this. So in the alternate scenario of filing the I-140, let's say in the next 2 to 3 weeks, and the marriage happens 3 months down the line, and then I try to get the I-485 filed and get the cross chargeability initiated, will that be not possible?
No, it is definitely possible. It is just less hassle to do it this way. If we go your way, there are a couple of things we have to consider. One, you'll have to get H1 extension, right?
Right.
Second, you'll have to file I-140 premium processing because once you get the
Yes.
I-140 processed, then you can get a 3-year H1 extension. If you're comfortable with that outcome, you can go this way. But also, because the earlier you file your 485, the earlier you and your spouse get your green card. Those are the 2 or 3 reasons I was recommending the first course of action.
Okay.
So the
Okay.
decision is yours. Now you are armed with information as much as I have. So ultimately, you have to decide how that information fits your personal circumstances.
Yes. Yes. Yeah. Yeah. Okay.
You
That was
know,
helpful.
yeah. If you have
Okay.
like DDLJ type scene, Dilwale Dulhaniya Le Jayenge. If you get married and her parents will shoot you, of course you don't want to do it before. So it's really it's a personal decision. It's not something I can comment
Right. Right.
on. All right.
Yeah. I mean, of course, there are personal and professional priorities, and I'm trying to get the things done in the best way possible. But
Sure.
this definitely helps.
Good.
That of course it will be less hassle to get all of them done at the same time, and it could be done just by a court marriage document as well.
Definitely. No question about it. Okay.
Um, okay, if you have a few minutes, can I ask you one more question?
Give me 1 second. Let me send out one last call. Make sure nobody else is waiting. Guys, if anybody else has a
Okay,
question,
okay,
anybody has any question, press *3. Don't be shy. It's okay. There's so many people on the phone. Anybody has any question? I can't believe people are calling just to listen. There must be a question there somewhere. Okay. All right. Go ahead. We have a few minutes. You can go ahead with your question. Go ahead.
okay. Thank you.
Yeah.
Um, so in my perm petition, I need to now get the experience letters from my past employers, and my past employers being some of them being very large companies with 20,000 plus employees, they don't give documented experience letters saying that such and such person did all these 15, 20 tasks in his 1 or 2 years of employment with us. So my best possible option is to get such an experience letter from a past colleague who is now not even at the same company where I worked. So I was told by the attorney that I can get an experience letter from a past colleague who may not be at the same company where we work together. But is that something typical practice, or what
No,
is a better way of getting it done?
that's
That's
please play this. Feel free to play this for your lawyers. I think this is very odd way of processing cases. Okay. Um, in my view, no lawyer should file a perm before having experience letters in hand because sometimes the slightest variation in what you think you can get and what you actually get can lose your case for you. I'll give you an example. Many years ago, I did a consultation for somebody who had Sun operating system in their background, but their labor certification required IBM UX. It's a Unix brand, but it's a different Unix brand. Their case was denied, and when they consulted me, I said, "There's nothing I can do about it." Because when your lawyer filed your case, they should have looked at your experience letter before filing the case. And they should have prepared the case to make sure you qualify for the job. So, first thing, no lawyer, in my opinion, and I don't know of any uh, people in my immediate acquaintanceship who will file cases like this. I think that's just odd. Number one. Number two, there is a law that says you must present primary evidence. So if the proof of your experience is through an experience letter from the old employer on their letterhead, signed by their um, responsible employee, you must present that letter unless you can prove that you cannot get that letter. Only then can you start getting secondary evidence, such as letters from colleagues. So this is an odd way to process cases. Beats the heck out of me how people do it that way. But you must excuse a non-availability of primary evidence before you can submit secondary evidence. What you're asking me is way beyond the scope of what I can discuss here. But get back with your lawyers, figure out the details of what you should present and how. Um, the good news is many cases go through without too many problems. The bad news is if you get stuck with USCIS questioning, it could become complicated. At that point, even if you get denied, you can always get another lawyer and file I-140 again with new documentation. So the good news is I don't think you're going to be permanently damaged as long as you got the experience that you have claimed on your labor certification. But how to present it, get together with your lawyers, they can guide you better. Okay?
Okay. The key thing is that I must present the non-availability of my experience letter from the employer on their letterhead before I can get secondary evidence
That is not what I
from
said.
a past
That,
colleague.
that, that is not what I said. What I said was the primary evidence is an experience letter from the employer on their letterhead. But you have, if you're not able to get that, you should at least document the fact that you tried to get it. Okay. The details,
Sorry, document what?
I'm sorry, look, I have to go, but I'm just going to wrap it up really neatly for you. Uh, you must prove that you tried your best to get that letter. Okay. Now, whether you're not able to get because it's a large company, whatever that documentation is proving that you tried it, that's what would serve to excuse the non-availability of primary evidence. Okay. So please get together with your lawyers, figure out the details, but that's not how we do it. Maybe other lawyers do it. I think that's a very bad way of doing things. That's my opinion. Okay.
Okay.
Good luck to you.
Okay.
Well, guys, I'll see you
All right.
again. My pleasure. I'll see you again in 2 weeks. As always, I appreciate the opportunity to help you and assist you, and I appreciate you being here. Thank you all. Bye bye.
Thanks a lot, Rajiv. Really, this is very helpful.
My
Thank you.
pleasure. Bye bye.
Bye.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.